Hey, everybody, and welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel, doing what we do each and every Thursday night here on the channel. And let's do this live Q&A to talk about all things debt-related, whether it's bankruptcy, wage garnishment, debt collection lawsuits, or all those horrible things. We talk about some ways to put a plan together to deal with it and get that in the rear view mirror. Again, my name is John Skiba. I'm an attorney in the state of Arizona. My law firm is called the Arizona Consumer Law Group, but I've been doing the Consumer Warrior YouTube channel for quite some time. Gosh, it's been 7 or 8 years. And we actually hit a pretty big milestone today. I'm recording this in March of 2024. We hit 50,000 subscribers. So thank you. Thank you for everybody who subscribes to the channel, who supports it, who's here each and every week with these live streams, watching the videos. Gosh, we're coming up on 4 million views on it, which is really crazy to think of the reach that you can get with a YouTube channel. And so I appreciate all those who have subscribed. If you haven't subscribed, why in the world haven't you subscribed to the channel yet? Go ahead and do it. Do it today. Do it right now. Click on that little bell. That way you'll be notified each and every day when we put out new videos, just like this. So what I'd like to do, though, on Thursday nights is to go over questions, maybe things that you're struggling with. My little caveat to everything is that this isn't legal advice. This is some guy talking on YouTube, so take it for what it's worth. And I'm only licensed to practice law in the state of Arizona. So if you're in Arizona and you have a legal question or something that you need help with, there's links in the chat section where you can reach out and even set up a consultation and talk with me directly about it. And I do these consultations all day long, helping people with debt issues. If you're not from Arizona, there's also a phone number and a link down there you can click, and we can connect you with someone who is an attorney in your particular state. There's also some self-help tools that I put there in the chat section as it relates to Consumer Warrior University, all the courses I have on drafting answers, forms, templates, motions to compel arbitration, responding to summary judgment motions. Take a look at those, and then also some of our great partners that we have here on the Consumer Warrior YouTube channel. Solo Suit, there's a link there. They have some great tech that they use to help with drafting answers, dealing with debt settlement. And then one of the other people that I've been partnering with lately that has some really cool free things is Ascend Finance. I put some links down there to some of the calculators that they use to help you to see if you qualify for a Chapter 7 bankruptcy. We talk about Chapter 7 quite a bit on the channel. You do have to qualify for it. You have to pass what's called the means test. They look at income and some of your expenses and your household size. The link there in the notes with Ascend is a free calculator just to help you determine if you qualify. And then there's also one that takes it even to a whole nother level with Chapter 13 bankruptcy. If you're thinking of that, that's where you have to pay back some of your debts. The first thing people ask me in consultations on Chapter 13 is, okay, great, how much do I have to pay? And I have the very unsatisfactory answer of saying it depends because there's so many factors that go into it. This gives you a good idea. This calculator, again, they're free to use, of what it would look like if you were to file Chapter 13, what kind of plan payment you would have to make. So again, if you have a question, if you're on Facebook, put it in the chat, in the comments. If you're on YouTube, put it in the chat section. I'll put it up on the screen. We'll talk about it, see if I can point you into the right direction. Let's address some of the comments from the channel that people put up over the week. This one said, I was able to look, this was a debt collection lawsuit. I was able to look up my docket in the civil case system. Should I try to settle with Midland's attorney or take it to court? I don't even know what the amount is. I'm just lost. And, and that's why I did the channel. I can tell you that's why I do what I do, is because having a plan and some understanding of what the process is going to give you a lot of peace of mind. And, you're probably up at night stressed out about this kind of stuff. Understanding what's going to happen and probably better what's not going to happen is a great way of kind of alleviating some of that stress. So in most jurisdictions now, I shouldn't say most, but a lot of jurisdictions, you can look up online and you can at least see the docket entries. You can see if the lawsuit's been filed. So in this case, so like Midland Funding, junk debt buyer, if the lawsuit has been filed and whether it's been served or not, should you take it to court? It's already in court. That's what you need to recognize. It's already there. So if they've served you, that's when you have to file an answer. That's when you have to fill out that document that states whether you admit or deny what it is they're alleging. That's what Solo Suit, they have a good product for it. I have one for it as well through the Consumer Warrior University. to get something filed. My recommendation is typically to always file an answer because one, it helps it so you're not going to end up with a default judgment against you, and two, it puts you in a position where it gives you some more time to kind of develop whether you want to try to settle it. Not only that, when you file an answer, they typically have to then provide you with their documentation through their initial disclosures. So you're going to be able to see the monthly statements they have. You're going to see the bills of sale, the transfer documents. You're going to be able to see all of these things and determine if there is a defense there. You can determine maybe what they have, maybe more importantly, what they don't have. So that's what I would do. It doesn't hurt to reach out and try to settle it. I have clients all the time that come to me and say, hey, look, I know I've got a legit defense, but I don't want this thing taking over my life. Let's just offer X amount of dollars and have it be done. And you can do that because under the rules of evidence, under Rule 408 in most jurisdictions, settlement offers are not admissible in court. So if you go and say, hey, you're saying I owe $2,500, I'll offer you $600 to get this thing to go away. They can't then run in and say, hey, Judge, John offered $600. Clearly he owes the whole amount. They can't do that. So when in doubt, file an answer. But if you're looking to settle, reach out quick, see if you can get something in place. And if not, get an answer filed. So this person said, I don't understand how a company who buys your debt for pennies from the original creditor and then sues you can collect on the full balance. Yeah, this is where everything feels like a big scam. As far as the debt buyers, they go out and, when you explain the debt buying industry, even people who are impacted by it, they're like, man, that's a pretty good business model. Other than the fact that they are preying on people who are in their most horrible spot of their lives. Other than that, the business model is that the debt buyers, they go to creditors. So like we've talked about before, if you have a credit card with Chase Bank and you don't pay for 6 months, they're going to charge it off. Charge off, again, does not mean that they can't try to collect on it, but it does mean that they're counting it as a loss on their books. And so what they then do is they then package all these accounts that are delinquent and have been charged off, and they sell them in a portfolio to junk debt buyers. Now, junk debt buyers are these companies, and they're gigantic. Like Midland Funding, we talked about, their parent company is Encore Capital. These are giant publicly traded companies, Portfolio Recovery Associates, Encore, Unifund, LVND, Resurgent Capital, all these companies, they go in and they buy this debt at a huge discount. There was a study by the FTC that said that most debt buyers pay about 4 cents on the dollar. I've seen transactions where they paid less than a penny on the dollar for the debt. So if there's a $100 credit card that's owed, they go in, they're paying 4%, 4 cents on the dollar. Okay. So they're paying next to nothing for these accounts. And in exchange, the creditor, the original creditor, is transferring the rights to collect on that payment. So that's how that works. So, and it's legitimate. If they, this is called assignment of accounts or transferring or selling of debt. And so if they transfer, the original creditor transfers in exchange for a discount to the debt buyer can then file a lawsuit. And if they can prove all their elements, they're going to get a judgment for the full balance, contract rate of interest, attorney's fees. And so they're investing little. They're taking a gamble on this. They're investing a little bit of money in trying to buy the debt, knowing that there's a number of these accounts they'll never collect on, that people will file bankruptcy, all that kind of stuff. But if they can prove it, and the debt buyer in court has to prove not only that you had the original account, that you had the breach of contract, that you had the terms of the agreement, the interest rate, all that, but then they have to show that your particular account was transferred between the entities. If they don't do that, then they're not going to be able to collect on it. So that's why it feels just wrong that they're able to do this. You didn't have any agreement with them. There's no what we call privity of contract between you and the debt buyer. So how is it that they can sue you and collect on it? That's how. And if you look in the terms and conditions of your credit card, there's an assignment provision that says that, hey, we can give this to whoever I want. You're probably more familiar with this if you've had a mortgage loan. When you go out and buy a house, you sign on the dotted line for a mortgage and it's with one bank. And then like 30 days later, you're getting a statement from somebody else because they sold the account immediately. That's frankly what led to the recession in 2008, was just this kind of transferring of loans gone amok. This person said, what about the people who are going to get your debt lowered and you just pay monthly to them? So this is a debt settlement question. This is a good one. I see this a lot. So there's companies out there and they say, hey, look, we'll help you settle your debts for pennies on the dollar. We're going to get you a much better deal than if you're paying them directly. And the way that they work is they say, go ahead and pay us, start paying us monthly, and then we'll reach out to your creditors and we'll negotiate a settlement. What I feel like they don't make clear, or at least what people don't understand, is what they're doing is you're paying them monthly. Let's say you're paying them $500 a month. They're going to take their fee off the top, whatever that is. They take $100 off and they put $400 in like a savings account or an escrow account. And then they try to build up a balance in the savings account. And then once they feel like they have enough to reach out to your creditors, they'll start reaching out and trying to negotiate it. The problem I see with this is your creditors are not on board. Most people that sign up for these companies, they feel like, hey, I've got some peace of mind. We're doing something. I'm paying this company. I've hired them. I'm paying them money each month. We're going to get this thing dealt with. And then all of a sudden they just get hit with lawsuits from everywhere because what the companies are often not telling you is that they're building up this balance. They're essentially acting as your savings account, but the creditor's not on board. So you have your Citi card out there and they're like, what the heck? We're not getting paid. And it's not that, and the company you hired, they're not reaching out to them until they have enough money where they think they'll accept the settlement. Sometimes that's 50, 60, 70% of the total balance. And so I've seen it work, but I've also seen it not work in a lot of situations where people have paid a ton of money on these things only to get hit with all these lawsuits and end up filing bankruptcy anyway. So something to really be careful about. Usually the situations where I see that it works is where you have fairly limited debt. Frankly, you could probably do it yourself at that point. So, all right, let's jump in here and let's get to some of the questions. I saw Rob was here nice and early. Rob says, I noticed the account number I'm being sued for is not the account number I had. They showed a credit card statement I never received from the original creditor that shows a different account number. An example of this, I have the original statement dated August 2019 with my account number, but as Exhibit A, they show a statement from September 2019, and it's a different account number. So, Rob, you're bringing up a good point. I can tell you as an attorney here in Arizona, when I have a client who gets sued by a debt, whether it's an original creditor or debt buyer, and they send over all their documents and monthly statements, I go through each one. I go through each one and do exactly what you're doing, making sure the account number is lining up, making sure that I've talked about before, an affidavit once I got from a debt buyer, an affidavit is a sworn statement. The name of the person at the top of the affidavit and the person who signed it were two different people. That case got dismissed immediately. But if you go through and really just be very detail oriented, go line by line and make sure that everything's at least as they're alleging, you're going to find situations like this where the account numbers are wrong. Because I can tell you this, like monthly statements, they're not giving you photocopies of your monthly statements. These are reproductions. And you can tell this, one way you can tell that a reproduction of a monthly credit card statement, I've seen this. The statement will be dated 2006. They have some old monthly statement. Look at the advertisements. You know how there's advertisements on your credit card statement? Look at what ads are showing up there. I've seen it where the account is 2006, but it's referencing something that's present day. And that's because they're recreating this. The computer's just reprinting it and putting the ads from now that they're printing out on their statements on this older statement. Stuff like that are reasons to object to the evidence, saying it's not legitimate and the court should not. It's not authentic. It's not the actual copy of the statement. This is something that who knows could have been reproduced. And you get mistakes like this with account numbers. So something to take a look at. Crystal says, love the channel. Thank you, Crystal. Hopefully you're one of the 50,000 subscribers we have now. We're trying to get to 100,000 subscribers before the end of the year. So let your friends and family know about the channel. JDB, junk debt buyer, filed an MSJ. It's kind of like being in the military, dealing with all these all the acronyms here. The junk debt buyer filed a motion for summary judgment. Do I file a motion to dismiss, then compel private arbitration? Do I need to respond to the motion for summary judgment? So there's a follow-up, said we had a pretrial conference, agreed to work on it, and then they filed the motion for summary judgment, said we can still talk, which I feel sucker punched. Yes, I see that a lot. So I can tell you, as far as once the motion for summary judgment has been filed, it's unlikely that you're going to get a motion to compel arbitration granted. Because essentially, in kind of to get to the next question, you need to respond to it. Yes. In most jurisdictions, you have anywhere from 14 to 30 days to respond to it, and it's got to be a substantive response. That's why in the Consumer Warrior University, I prepared a tutorial just on responding to summary judgment, because it's much different than responding to just the answer. It's much more in depth. A lot of information that's needed to be able to defeat it. You've got to really pick apart their evidence. So usually that's why I recommend the motion to compel private arbitration. That needs to happen usually instead of the answer or shortly after the answer, because once you wait until the motion for summary judgment has been filed, it's hard to do it. So, and the situation here where you go to the pretrial conference and they're like, oh yeah, let's work something out. I can tell you this, kind of how most debt collection firms work. They have relatively few attorneys. They have a lot of cases, and they have a machine. Everything's automated. And so often, that summary judgment motion has been in the works, and they're just kicking that thing out, even if the attorney, they don't know what the attorney said in many situations. So, that's what I would say is that's probably why it happened. But yes, make sure you figure out. And I thought you said you were in Arizona. Let me just double check. Yes, because Crystal, you're in Arizona, you have 30 days from the day that they mailed it to you to file your response to the court. Make sure you do that. Again, you can check out some of the templates and tutorials there in the chat section that may be able to help you out there. So, all right, let's see here. See what Ray has to say. Texas Justice Judge says private arbitration is not an option in justice court. The plaintiff did not purchase the contract, only the debt. So she doesn't care about the terms and condition. My thoughts. So here's there's two lessons. One, judges can get it wrong. Judges can absolutely, they come to the thing with their own experience, sometimes just like in Arizona, the justice of the peace, many of them are not attorneys. Most of them are not. They haven't been to law school or anything. They're elected. In Arizona, the only thing you need to be, there's three things. You need to be a justice of the peace in the state of Arizona. You need to be 18 years old. You need to read and write the English language, and you need to be elected. Those are the only three things. And sometimes, truthfully, I have a lot of sympathy because they're put into this situation where these attorneys are bringing legal arguments to them all day long, and they may not be fully equipped just based on their educational background to deal with it directly. So it's not an easy job. But a situation like this, so let me tell you this. Arbitration, there's two issues here. The arbitration clauses in the terms and conditions, they will often say that they don't apply to small claims court. Now, if the justice court is a small claims court, that may be an argument that's legitimate. But most small claims courts do not allow attorneys. And most states do not allow companies to be represented by anybody but an attorney. So most collection cases are not filed in small claims. That's rare. These junk debt buyers, they have whole teams of lawyers that are working on this. They're not filing this in small claims. Now, the terms and conditions, here's what I tell the judge is, look, okay, the junk debt buyer, to say that they bought the debt, the only way they buy the debt is by stepping into the shoes of the creditor, the original creditor. And when they step into the shoes of the original creditor, they are subject to the good and the bad. The good being that they're going to be able to try to collect the full balance. The bad, they're subject to the terms of that arbitration clause. And that's how I would frame it to them. I would say, look, they didn't just buy the debt. They bought the whole account. They bought all the rights. I mean, the terms and conditions is what allows them to charge like the default rate of interest of 30% that they're screwing you with. So those are the kinds of things you need to press back on. Maybe file a motion to reconsider or something like that, because my opinion is that is just wrong. So this question says, I have been sued by Portfolio Recovery, been to court. One that the lawyer said they can't collect as I dispute it. What should I expect at the next hearing if I file for arbitration? So if you file a motion to compel private arbitration, what happens then is the other side gets a chance to respond to it. And then, in my opinion, the court should always grant it. But as we can see from Ray, our prior comment, it doesn't always happen. But if it does, then you need to be prepared to go and initiate private arbitration, usually with AAA, American Arbitration Association. And then the debt buyer can determine if they're going to follow you in there and deal with it, or if they're just going to dismiss. I always say this: if you're going to file a motion to compel private arbitration, you got to do it in good faith. You've got to be willing to go forward with it in the event that they follow you in there. Many times they don't, because the filing fees are high, and particularly if you're not getting sued for a whole lot, it's not going to make a whole lot of sense. But I can tell you, we filed one, and I did a AAA arbitration 2 days ago because the amount was fairly high, and they followed us in. So, and it's a whole different process in there. It's a little more loosey-goosey than it is in the court system. So, but that's what you can expect if you file that they're going to get a chance to respond to it, and then if the court grants it, it's going to push it into arbitration. All right, let's see right here. My neighbor could possibly sue me over a lot line and a fence issue. All right, we're diving into stuff that, that my advice is marginal at best. He wants a new dividing $90,000. Does that qualify for demand, or does he have to sue to initiate it? This is good. So lot line litigation is outside the scope of what I probably should have read that in detail. So Robert, unfortunately, I'm probably not going to. I would recommend contacting a real estate attorney on that. I used to work for a real estate firm. I've done a lot of real estate litigation. I just know that it's something you got to be careful of. Oh, you did have a follow-up question that makes sense. Will Chapter 7 eliminate this potential liability if I lost? That I can answer. Yes. Chapter 7 eliminates pretty much all unsecured liabilities unless there's a specific carve-out in the bankruptcy code that would allow them to not be eliminated. Like if it was for fraud, or if you're intentionally harming somebody, sometimes there's fee, child support, alimony, those kind of things. Other than that, it'll go away. And not only that, it would stop the litigation right from the get-go. So, Victoria, thank you for supporting the channel today. Sincerely, I appreciate it. All right, let's see right here. Let's actually go to Victoria. I filed a lawsuit against TSI after failure to validate. Their lawyer contacted me wanting to settle outside of court and indicated the original creditor took back the debt. Now what happens to the debt? Well, I mean, it doesn't eliminate your claim. If there's a Fair Debt Collection Practices Act claim, an FDCPA claim, just because they gave that back the debt doesn't mean that your debt is invalidated. I have seen that in rare cases where debt collector is one thing compared to a debt buyer, but I've even seen debt buyers who will transfer portfolios back. To me, that says there's something wrong with the portfolio, that there was either a bunch of cases that were outside the statute of limitations, or bankruptcy has been filed. So if it's still a legitimate debt, and it got transferred back, assuming that transfer was done appropriately, then the original creditor can decide whether they're going to pursue any type of collections. Statute of limitations is going right now. And so one of the things I recommend, if you're dealing with any kind of credit card debt, find out what the statute of limitations is in your particular state. Just Google it. What's the statute of limitations on a credit card? And wherever. In Arizona, it's 6 years. Most states are between 3 and 10 years. And just make sure that it's not something that's already outside the statute that you should ignore. So, all right, let's see here. Alex, my man down in Yuma. If you file a motion to compel private arbitration, will the creditor proceed with the arbitration? What if they do? Yeah, I kind of talked about that just a bit. Some of them will. Like I said, I know they will because I did an arbitration 2 days ago in AAA. It was for a much larger amount, 20,000 plus kind of thing. I've had a number of them dismissed, though, particularly the ones that have the smaller amounts. So if they do, you just need to be ready to go forward. Now, the arbitration process, it's different from the court process in that typically the rules are different. There's rules of arbitration. It's going to be heard by an arbitrator. It's much less formal. I know our arbitrator we did it via Zoom, and he was in like a tracksuit, like a sweatsuit kind of thing, which is fine. But he's qualified, knew what he's doing. He's an attorney. But it's something where, and the rules that they can be a lot more lenient on what comes in, what doesn't, and kind of peeling things back. And the arbitrator can ask questions, which is kind of interesting. Like judges usually don't ask questions like that. It's usually the arbitrators that are able to do that. So that's kind of what you can expect from there. All right. This one says, if I file bankruptcy chapter 7 and one of the debts I owe is for a joint auto loan, is it removed for the joint person as well? Great question. Difficult kind of position. So if you file chapter 7 bankruptcy and you've co-signed on the car, let's say that your brother, you co-signed on your brother's car and they're making the payments, they drive the car, that kind of thing. Your bankruptcy will eliminate your liability on that vehicle. It does not eliminate the other co-signer's liability on the vehicle. And if the payment is not made on the vehicle, it'll be repossessed. And so it's important, particularly if you're filing with an attorney, let your attorney know if there's a co-signer. That way they can walk you through any potential issues that it may be there. The only way the co-signer is going to get off the loan as well is if they file for bankruptcy as well, or the vehicle surrendered. But even then, they could come after the other party for the balance there. So, all right, let's see here. This one says, why would PRA, Portfolio Recovery Associates, hire an outside attorney to be present in Kentucky when they're based in Virginia? So what you're seeing there is, so when you get sued by a creditor in the upper left-hand corner, that's where the attorney's information is. You're going to see that Portfolio Recovery Associates is based out of Virginia. They also have an office in San Diego. And so often you'll see that they put that home address. And what they do is they have all their mail come to one place, I'm sure, so they can just process it and then send it out. But they have individual attorneys who actually live in the States. So I know, for example, in Arizona, the in-house attorneys for Portfolio Recovery Associates, they have 3 of them. And I don't even believe they maintain offices. I think they just have a home office. All their support staff and everything is in Virginia or San Diego. And that's why you're seeing, if you're in Kentucky, they're going to have probably a local Kentucky attorney who actually is an employee. It could be one of 2 things. They're an employee of Portfolio Recovery Associates, or they're actually hiring out just a local attorney to come in and handle it. So, all right, man, CA Slots, thank you. Received a summons. Can you help me in California? I cannot. I'm not licensed in the state of California. I'm only licensed in Arizona. And so what I can do, though, there is a link below. If you click on that, we can connect you. There's a law firm in California that I recommend. You know what? Let me see if I can find it. See if we can do this in real time here. I don't know if I can. Let's see. I thought I could. Oh, I did. You know what? I'm going to send you to some attorneys I know who do what I do in California. I'm going to post this in the chat section there. This is the Fulman Law Firm. They're in California, and they help with, you can let them know that I referred you, and they deal with what I do. They don't do bankruptcy at all. They deal with lawsuit defense, and they do a good job. Good group of attorneys there. So, all right, let's see if there's anything else. This person said, let's say, it says, I'm thinking there was a question before. Okay, let's talk. Let's do this one first. Joshua says, I lost my job and I'm waiting to file Chapter 7. Is it better to wait for the 6 months since having the money to wait? Lost my job waiting to file Chapter 7. Is it better to wait for 6 months since having the money to wait? So my means test is in my favor. Is that considered structuring filing, aka fraud? Don't want to do any fraud. Also, does it look sketchy to the court if I get a job right after or during bankruptcy? Love your videos. Thank you, Joshua. So, the question as far as the means test. So the means test, when we're determining if you qualify for a Chapter 7, we look at the 6-month window prior to the filing of your bankruptcy, not including the month that you filed in. So if you file your case in March of 2024, we're going to look from February 29th, because it was a leap year. We're going to go back 6 months, and that's how we're going to determine. So if you qualify now, you can go ahead and file. If it's something where you don't qualify because your income is too high, but you just lost your job, it may be something, if you wait 2 or 3 months, you do qualify. And no, that's not fraud. That's just dealing with life as it comes at you. It's something where you're like, hey, my income has gone down. I've had this with Chapter 13 bankruptcy clients where the income goes down significantly during the Chapter 13, and we convert it to a Chapter 7 because they now qualify for a 7. So I think that, you'd be fine to do that. And does it look sketchy? No, I have clients who change jobs all the time. I have clients who change jobs 2 days after they file Chapter 7. Chapter 7 bankruptcy is more of a backwards looking process. They're looking at the date of filing backwards as far as your income goes. The only thing that they care about going forward as far as income is usually if you get an inheritance in 6 months from the time that you filed your case. And sometimes like tax refunds, or like if there's like some kind of settlement in a case, that kind of thing. So like a personal injury type claim. So, all right, let's say here. Mike says, I filed a motion for summary judgment based on I got to go back one. Clearly I'm doing this myself. I need a production assistant here. What can I do about a judge that seemingly won't rule on a motion for summary judgment? I sent a request for admissions and they were deemed admitted by default by failure to respond. I filed a motion for summary judgment based on those admissions in November, but the judge has still not issued a ruling. Is there anything else I can do? So this kind of falls into the category, it's their world, we just live in it kind of thing when it comes to judges. However, and just to give everybody some context of what you did here. So requests for admissions, these are written discovery tools where you can send over a request where they have to just admit or deny it. And there's a timeline associated to respond. It's usually 30 to 40 days. And if they don't respond, those requests are deemed admitted. You often see junk debt buyers do this to consumers. They'll send out a bunch of requests for admission, say, admit that you owe us $10,000. Admit that portfolio recovery is the proper owner of this account. Simple. No, you don't. If you deny it, you can deny it very simply. But if you don't respond to it, it's deemed admitted, and then they attach it to a motion for summary judgment and say, look, judge, they've been deemed to admitted everything. So this looks like Mike here played the old switcheroo on them and had that happen. So you file your motion for summary judgment. They don't respond to it within the time. In most jurisdictions, failure to respond to a motion is their consent that it be granted. So what I would do, I would file what's called a motion for summary disposition. Again, motion for summary disposition, just outlining kind of what you did in the comments here. Judge, I filed my motion in November. The 30 days have come and gone. They haven't responded to it. I'd ask that a ruling be had and that it be granted. Sometimes that's kind of the prod. Judges have often hundreds, in some jurisdictions, they have thousands of cases. The justice courts in Arizona, they deal with landlord-tenant cases, civil cases, criminal cases, debt collection cases. They deal with everything. And so sometimes you have to really kind of, be the squeaky wheel to get the attention that you need. All right, let's do one more. This one's by Brian, says, is there a hold on VA loans for foreclosures? I have not seen any specific statute or rule coming out as far as if there's anything specific. I do know that foreclosures are going up. Actually, there were several states where they were showing that they're actually kind of getting scary high. It's reminding me again of 2008 in the prior recession. And I've been meaning to do a video actually on foreclosures, because foreclosures, if you're behind on your mortgage, one way to deal with it is a Chapter 13 stops a foreclosure sale, and then you have up to 5 years to get caught up on your thing. So, all right, let's do one more here. It says, if I inflated my income on an application because of expected income that I ended up not earning, am I at risk of not having my debt discharged in a Chapter 7? I don't know. If you're in the state of New York, I think this is what Trump just got nailed on. I'm just teasing you. So let me tell you. So if you file bankruptcy, one of the exceptions to discharge is fraud. And so if your income was inflated, and part of what fraud is that you knowingly made a misstatement or a misrepresentation. So if you made a misrepresentation upon basically, you had a raise and it was supposed to be coming through, and then so you put that down and then it doesn't come through, no, that's not fraud. But not only that, the creditor has to come in and object to the debt from going away. It's not that it just doesn't happen. It's something where they actually have to come in and file an adversary complaint saying that debt is not discharged. So I would talk to an attorney, a bankruptcy attorney in your jurisdiction for sure, just because that's something that's really fact specific, and you need to be prepared for it if it's going to be an issue. So, all right, I think we'll just close it up there. But hey, thanks everybody coming in tonight. Again, and thank you again for all those who subscribe to the channel. We're at 50,000. Go subscribe if you haven't already. Let's get that up to 100,000 before the end of the year. And then please check out those people who help sponsor this, Solo Suit, Send Finance. Check out their information over there. Great friends of the show. And I appreciate all you checking in tonight, and we will catch you next week.